Leadership by deception is not leadership by any definition, it is fraud. As more is revealed of the sheer deception perpetrated against the American people by the Justice Department and the FBI, the rampant corruption in Washington grows more difficult to hide. It seems almost daily, sometimes by the hour, more is revealed of their dastardly deeds. Now the FBI and the DOJ have been caught red-handed not only redacting documents in an effort to cover their criminal dealings, they have also been caught manufacturing fraudulent documents. They are essentially creating evidence to fit the narrative they want the American public to believe occurred regardless of what the actual facts are. Both entities are now colluding to actively obstruct the congressional investigation in an effort to hide their crimes. They will not provide Congress with documents requested under a subpoena, claiming national security interests. They will only allow Congress to review heavily redacted versions of the documents in question in a secured FBI or DOJ location. This process has enabled them to swap documents or create two versions of the same document so as to continue their deception. From the beginning, Rep. Sheila Jackson Lee, TXD, and Rep. Gerald Nadler, NYD, incessantly questioning the validity and the necessity of such a hearing. Points of order were loudly raised by Rep. Ted Lieu, California D., as the Strzok testimony was raised in questioning by Rep. John Ratcliffe, TXR. It seems the Democrats were especially nervous and were acting out in contrary and contentious ways throughout the hearing. Almost childlike in their reactions, it appears as if they were especially worried as to what Rosenstein might have to say. Now they have been caught as a result of damning testimony inadvertently provided by Deputy Attorney General Rod Rosenstein stemming from some excellent questioning by Rep. Matt Gaetz, FLR. Oh, what a tangled web we weave. Here is a transcript of the Gaetz-Rosenstein exchange. In the exchange, Carter Page's FISA application is discussed. It was also discussed extensively in both the Nunes memo and the Grassley memo, and later on, it was also discussed in the Schiff memo. That is an important connection that is not to be missed. Gaetz, did you read the FISA application before you signed it? Rosenstein, I won't comment about any FISA application. Gaetz, you won't say to the committee whether or not you read the document you signed that authorized spying on people associated with the Trump campaign. Rosenstein, I dispute your characterization of what that FISA is about. Sir, did you catch that? Rosenstein makes the statement in response to Gaetz's question. I dispute your characterization of what that FISA is about. Vague and open-ended, but not necessarily inconsistent. Remember, Page had left the Trump campaign prior to the FISA warrant being issued. However, the Page warrant specifically allowed for what is known as two-step surveillance. That means people associated with Page, and likely still involved with the Trump campaign, could and were surveilled using that warrant. Rosenstein, my responsibility at that time was to approve the filing of FISA applications, because only 3 people in the department are authorized to sign it: the Attorney General, the Deputy, and the Assistant Attorney General for National Security, which was vacant at the time. We sit down with a team of attorneys from the Department of Justice, all of whom review that and provide a briefing for us for what's in it. And I've reviewed that one in some detail, and I can tell you the information about that doesn't match with my understanding of the one that I signed. But I think it's appropriate to let the Inspector General complete that investigation. These are serious allegations. I don't do the investigation. I'm not the affiant. I'm reviewing the finished product. Sir, if the Inspector General finds that I did something wrong, then I'll respect the judgment, but I think it is highly unlikely given the way the process works. Of note, the Page FISA application was viewed by the following members of Congress on or before January 31, 2018: Chuck Grassley, Bob Goodlatte, Trey Gowdy, Lindsey Graham, Gerald Nadler, Orstaff, John Ratcliffe, Adam Schiff, Dianne Feinstein, Sheldon Whitehouse. Now follow along with me if you will. In a letter dated April 6, 2018, Assistant Attorney General Stephen Boyd allowed all House and Senate Intelligence Committee members to view the FISA application, which was a highly unusual step in and of itself. Boyd's letter explains in part that the department and the FBI agreed to permit all members of the House Intelligence Committee to review the FISA applications and renewals in camera at the department. The department considers this an extraordinary accommodation based on unique facts and circumstances. That invitation to review the documents was also extended to the Senate Select Committee on Intelligence. Did you catch that? The DOJ agreed to allow all members of the House Intelligence Committee and the Senate Intelligence Committee to review the Carter Page FISA application, except there was one problem. And it is a problem of some significance. It seems there were two different versions of the FISA memos presented by the FBI. One memo is the same presented to the FISA court and signed by Rosenstein. The other memo is the one members of both the House and Senate Intelligence Committees were allowed to see. Either the documents were illegally duplicated or Rosenstein just lied under oath, both of which are crimes. The public information on the Carter Page FISA application does not match the briefing Rosenstein received prior to signing the renewal. Consider the ramifications of this revelation and the long-term implications. These documents are sworn to, under oath, and vetted by FBI agents. Consider the ramifications if they are false. Or is it the leaks regarding what is actually contained within the FISA application itself what is false? Rosenstein signed the final FISA renewal on or about June 29, 2017. Robert Mueller was appointed as special counsel on May 17, 2017, just under a month prior. On July 27, 2017, the Inspector General Michael Horowitz Mueller of the Strzok Page texts. On August 2, 2017, Rosenstein issued Mueller a revised scope of investigation and definition of authority memo. It was heavily redacted. What we do not know is when, and if, Rosenstein discovered the discrepancies regarding his briefing for the FISA renewal and just what those discrepancies might be. If Rosenstein was correctly briefed and the press reports are wrong, who leaked the information? Why did they leak wrong information? To what end and how does it differ from the actual FISA application?